The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 932, coming to you on Monday the 1st of April 2019. On this program, I will continue the topic I started last week, Monday. So this program is called the Election Petitions Judgement Part 2. And just before resuming my reading of the judgment, short preliminary, deepest condolences to all families which have suffered recent bereavement. And I just say very briefly that with this talk of the possible invasion of Venezuela, I cringe because not only would it be sheer lunacy for any country to invade Venezuela, but if that happens, all of us in these OECS states would suffer the consequences. I hope people think twice, 3 times, and 4 times before making any such decision. It would be sheer madness, in my respectful opinion. Anyway, I started reading the last few pages of the judgment of Mr. Justice Stanley John as he delivered his decision in the election petitions cases on the 21st of March. I had reached halfway in paragraph 57, but I want to resume today's reading by going back to paragraph 56. And here goes. This is what the judge said. The locus classicus in the region. Locus classicus means the most authoritative case on the point. So locus classicus means the case that is the case of all cases on a certain point. So the locus classicus in the region, on the true meaning of the phrase substantial compliance, continues to be the judgment of Chief Justice Rawlings in Quinn Leandro versus Jonas, where the Chief Justice had this to say, quote, "An election court would not invalidate an election on the ground that there was substantial non-compliance with electoral law, pursuant to Section 32, subsection 4 of the Representation of the People Act, if the breach of elections procedure stipulated by the law was trivial. There had to be such a substantial departure from elections procedure stipulated by law that would cause an ordinary person to condemn the election as a sham or travesty. A considerable departure was required. Accordingly, an election court would usually only invalidate an election on that ground if the judge was really satisfied that the breach was serious." Unquote. Those were the words of Chief Justice Rawlings in the seminal case in the region, Quinn Leandro versus Jonas. Justice Stanley John continued, paragraph 157. Later on, at paragraph 180 of the judgment, Chief Justice Rawlings said, quote, "However, I think that for good reason, the authorities seem to show that where there is evidence that includes statistical data and other relevant information from which a court may determine, even inferentially, that the breach did not affect the result, Proposition 4 is not to be applied without first attempting to determine whether the result was affected. This is because an election in a democratic society is for the purpose of determining the will of the voters. The court must seek to determine this as far as it is possible when an election is challenged," unquote. That was the end of the quotation of Chief Justice Rawlings in the Leandro case. Justice John continued. The learned Chief Justice then referred to the approach adopted by Justice Newman in the case Considine versus Didrich. Quote, "Does it appear that the breach did not affect the result? The most relevant factors are the following. The majority was only 7. The number of Derringham Ward voters who received Marfield ballot papers is not known. 17 persons have made statements saying that they did not receive ballot papers for the Derringham Ward. Another 68 voters did not initially receive ballot papers for the ward, but then applied for them and received them. 779 voters were registered in Morehouse Road and Wall Road, which were the roads most affected. An unknown number of voters did not apply for replacement papers because they understood that they did not need to do so. I can only conclude that the breach may well have affected the result and therefore that it does not appear that it did not affect it. Section 48(1)(b) is not affected. So the election, in that case, must be declared void. I appreciate that this conclusion is one which is not reached lightly because, apart from other aspects, an election is an expensive matter," unquote. Justice John continued, "A sound statement to recall the proof that one is required to meet in order to succeed on a plea that breach of electoral law affected the result was provided by Justice Newman in the English case Edgell and Glover as follows," and this is what Justice Newman said in that case. "Having regard to the consequences of having an election, for the court to conclude that the result is affected, there will need to be a preponderance of evidence supporting that conclusion." Justice Newman in that case further said, "Having regard to the terms of Section 48(1), there should be no declaration that the election is void or invalid unless it appears to the court that the result was affected," unquote. Justice John, having quoted those quotations from other cases, continued in his own words. Excuse me, please. And this brings me to paragraph 159. Justice John said, In treating with Section 48(1) of the 1983 Ballot Act of England as an enabling section, Justice Newman in that case held that Section 48(1) can be translated and understood as creating a positive duty, with the consequence that an election must be declared invalid by reason of any act or omission of the returning officer if it appears that the election was not so conducted as to be substantially in accordance with the law as to elections, or that the act or omission did affect the result. And the negative form of the section means that both substantial compliance with the law and no effect upon the result are required to save breaches of duty or the rules from voiding the election. Section 33(3) of our Representation of the People Act is in pari materia, that is on all fours. It's basically the same as Section 48(1) of the 1983 Ballot Act of England. Paragraph 160. Justice John continues. It follows that Section 33(3) of the Representation of the People Act of St. Vincent prohibits the court from declaring an election invalid where the court finds a breach or breaches of an official duty or of the rules, and it appears to the court that the breach did not materially affect the result of the election. Section 161, paragraph 161, succinctly, if there is substantial compliance with the law as to elections, but it can be shown that the acts or omissions affected the result of the election must be voided. Similarly, if there has not been substantial compliance with the law as to elections, even if the acts or omissions have not affected the result of the election will also be voided, that is, declared null and void. Paragraph 162, Justice John continues. In the case Wayne Monroe and others versus Maxi Coffey and others, Justice Apopil Jamada in the course of judgment posed the question, quote, what is the proper interpretation to be given to Section 35(3) of the Representation of the People Act, which is equivalent to Section 33(3) of the St. Vincent Act? Justice Jamada said at paragraph 87 of his judgment in that case, quote, in my opinion, the construction that is most legitimate is to limit its application to breaches of official duty and to do so generally in relation to the election rules. That is to say, it is only in the limited and specific circumstances where what is alleged and proven to have occurred are acts constituting breaches of official duty as statutorily prescribed, that subsection 35(3) can be relied on to save an election from invalidity, unquote. Justice John continued. Section 35(3) of the Trinidad and Tobago legislation uses the word materially, whereas Section 33(3) of the St. Vincent legislation uses the verb substantially. As to the learned justice of appeal, as the learned justice of appeal said at paragraph 95 in that Wayne-Marino case, the adverb materially introduces both qualitative and quantitative elements of significance. Thus, to quote, not materially affect means not significantly or appreciably or fundamentally or substantially or essentially have an effect on the election of a member of the House of Representatives. Justice John. Conclusion. Paragraph 164. The court has been taken through several authorities by both Mr. Stanley John QC for the petitioner Exeter and Keith Scotland for the petitioner Batiste, as they endeavored to persuade the court that in light of the breaches, the court ought to find that there was substantial non-compliance. The court has carefully analyzed all the authorities. He said at paragraph 165. The cases have all clearly established that the courts will strive to uphold an election as being substantially in accordance with the law, even where there have been serious breaches of the rules or of the duties of the election officials, provided that the result of the election was unaffected by those breaches. I think I ought to read over that paragraph because it's the nub of Justice John's decision. So let me read over paragraph 165. The judge said, the cases have all established that the courts will strive to uphold an election as being substantially in accordance with the law, even where there have been serious breaches of the rules or of the duties of the election officials, provided that the result of the election was unaffected by those breaches. I pause here to give a word of clarification if any is needed. What the judge was saying in that paragraph is that the cases, the precedents on which everybody has to rely, judge and lawyers, establish that even if things were done wrong, even if there were breaches of the election rules, even if the officials made mistakes, the court will still allow the result of the election to go through if it is satisfied that those mistakes or lapses did not substantially affect the result. That is what he was saying, and that is the gist of his judgment in these two election petition cases. Excuse me. Paragraph 166, the judge went on to say, the voter turnout in Central Leeward was 76%. By any stretch of the imagination, that is considered very high. In the case Halstead versus Simon, Justice Redhead made the point that, quote, and this is what Justice Redhead said in that case, in determining whether or not there is substantial compliance with the law or rule as to the opening and closing of the poll, one is not or should not be confined solely to the number of polling hours which was lost, but with what was achieved. That is the number of votes which was cast during the polling. Unquote. Justice John continued, paragraph 167. Like Central Leeward, there was an overwhelming expression of the will of the electors in North Windward. There was a voter turnout of 81.5%. Mr. Montgomery Daniel gained 2,713 of the votes cast, as against the petitioner Lauren Batiste, who gained 2,390 votes. The high voter turnout in this constituency is an expression of the will of the electorate, and which the court will not lightly disturb. The judge said in paragraph 168, the court has already alluded to the findings of fact in the trial. The petitioners have failed to satisfy the court on direct, creditable, and compelling evidence on the many serious allegations that they have pleaded. As Justice Redhead said in Halstead versus Simon, quote, it is not the court's function to say who should win or lose. The court's function is to declare on the basis of the evidence and the law whether the result was affected or might or have been affected by the irregularities. Paragraph 169. Justice John, the court holds that the breaches which took place during the general election in the constituencies of Central Leeward and North Leeward did not affect the result of the election from a qualitative or quantitative perspective. Let me repeat. The court holds that the breaches which took place during the general election in the constituencies of Central Leeward and North Leeward did not affect the result of the election from a qualitative or quantitative perspective. Excuse me. Paragraph 170. Accordingly, these two petitions must fail on the basis that it appears to the court that, having considered all the evidence that the election was conducted substantially in accordance with the law as to elections. Further, the court is satisfied that the acts and omissions, either separately or collectively, for which first respondent Winston Games and other election officials were responsible in connection with the election, did not affect the result of the election in either of the two constituencies. Paragraph 171. The petitions are hereby dismissed. Paragraph 172. On the question of costs, the court applies the usual order that costs follow the event. The petitioners will pay the respondents' costs to be assessed if not agreed. Paragraph 173. The court takes the opportunity to thank all counsel for their immeasurable assistance during the trial. This trial has been conducted by all of the parties in the highest traditions of the bar. The level of professionalism displayed is highly commendable. It augurs well for the legal profession in St. Vincent and the Grenadines. Final paragraph, paragraph 174. This is what Justice Stanley John had to say. Last paragraph of the judgment. This case has highlighted the need for proper training of persons who perform official duties in elections. That, the court believes, will alleviate the many irregularities which have arisen in this case. Let me immediately say that it is not true to say that the judge said there were no irregularities in the election in Central Leeward and North Windward, as some people have said. The judge said nothing of the sort. He said in paragraph 169, the court holds that the breaches which took place during the general election in the constituencies of Central Leeward and North Windward did not affect the result. He didn't say there were no breaches. And he ended by saying, the case has highlighted the need for proper training of persons who perform duties in election. That the court believes will alleviate the many irregularities which have arisen in this case. So the judge is saying, yes, there were many irregularities in the elections in Central Leeward and North Windward. But the judge says together, those irregularities did not justify declaring the elections in those two constituencies null and void. That is what the judge said. Now, objective lawyers, that is, lawyers not committed to NDP or ULP, but neutral lawyers have read this judgment. And all of the lawyers that I have heard speak on the subject, and not every lawyer I have heard speak, but every one of them, and I'm talking about more than 14 or 15, that I have heard speaking about this judgment, have said the judgment was thorough and it was sound. So I can safely say that an overwhelming body of opinion of the lawyers in St. Vincent feel that this is a sound judgment. Personally speaking, I think the law has discussed all the cases dealing with elections, all the important election cases, not only in the Caribbean but abroad. And I think he has arrived at a sound result. But if the losing side files an appeal, which they have said they are contemplating doing, power to them, that is their right. If the matter goes on appeal, we will have to wait and hear what the Court of Appeal has to say. But I would only say this in closing. I hope that those on the NDP side would not do that which they did while waiting for this judgment. You know, when the trial was finished, I saw on Eyewitness News a report that NDP headquarters had sent a message to all of its practitioners on radio and elsewhere that they must not discuss the case. And I felt that was wise. And not only wise, it was proper, it was in keeping with the tradition, because while you await a judgment in a case, it is not proper to go in public and be talking about the case and saying, look, this side is bound to win and this side is bound to lose. No. You wait on the result. You don't make statements of opinion as to how the case is going to be decided, especially if you are one of the lawyers who was involved in the case. You shouldn't do that at all. So when NDP came out with a statement telling their people, don't discuss the case, I said, I applauded Mr. Friday, Dr. Friday. I said, that is good. Lo and behold, the same Eyewitness News reported several public meetings of the NDP, at which all sorts of statements were made about the case, discussing the evidence and saying that we're bound to win because they thieved the elections. I was appalled when I read these statements in Eyewitness News. I said, surely they are misquoting people. But I saw no protest to say you have misquoted us and we never said that. Let us hope that if the case goes on appeal, that we won't have these public meetings and discussing the case and so on. Let us wait till the appeal is heard and wait for the decision. Because when you work up people to a frenzy and tell them, look, we're going to win the case, we're going to win the case, we're going to win the case, because the other side thief, and our evidence was strong and blah, 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 and you work up people, what you expect them to do when the result come back and you have lost? So the behavior of the people on the streets of Kingstown, when the case was, the decision was announced, was not surprising to me, because people had been worked up in a frenzy to believe we're bound to win these cases. And when it turned out that they didn't win the case, people turned beast and started to carry on in town. Closed down the town, traffic couldn't flow. It was a disgrace. Protests, yes, but not in that sort of way. And all sorts of statements made against the judge, how he this and he that and so on. Totally unnecessary. Totally unnecessary. So that is my reading of the concluding pages. You can find the judgment, if you want to go on the internet, on the Eastern Caribbean Supreme Court website. Easy to find, just Google Eastern Caribbean Supreme Court. Follow the pointers, you will see judgments, bang and judgment. Look for the case Lauren Batiste against Bill Davis and others, and Benjamin Exeter against Winston Games and others. And you can read the case for yourself. 63 pages of solid scholarship by Justice Stanley John, for which I applaud him. Well, that is all from this edition of The Law and You. I look forward to being of further service to you next week, Monday, Divi, for another presentation in this public service nation building series, The Law and You. Do have a peaceful, restful, and enjoyably pleasant week, ladies and gentlemen, brothers and sisters, boys and girls. And may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC, and brought to you on SVG-TV as a public service.